started.
All right, that sounds good. We can kick it off.
Justin, you're introducing us, right?
Yes. Yeah, I didn't know if have we started or.
We can start. We can start now. Yeah.
Okay. All right. Hello, everyone, and welcome to this week's presentation by the Georgetown Federalist Society. Thank you all for taking the time out of your evening to come and hear this exciting debate. I'd like to first welcome our first debater, Anya Bidwell. She is an attorney with the Institute for Justice and is the current Elfie Gallun Fellow in Freedom and the Constitution. She works to promote judicial engagement and ensure that government officials are held to account when they violate individuals' constitutional rights. She grew up in the former Soviet Union, came to the United States at the age of 16, and earned her JD with honors at the University of Texas, as well as a master's degree in global policy studies from the University of Texas. Our other debater tonight is Jason Johnson, who is president of the Alexandria, Virginia-based Law Enforcement Legal Defense Fund, an organization dedicated to educating the public about the many risks and threats to law enforcement personnel. He served as Deputy Police Commissioner of the Baltimore Police Department from 2016 to 2018. He is a graduate of the University of Maryland, Baltimore County, and the University of Maryland Francis King Carey School of Law. Moderating the debate tonight is Henry Dye, a current junior at Georgetown University, class of 2022, also a senator in the Georgetown University Student Association and current president of the Georgetown University College Republicans. And I'm Justin Drewer, introducing these wonderful people. So I'll hand it over to Henry to kick off the debate. Again, thank you all for coming, and please keep coming to these events. We usually have them every Wednesday. They're a lot of fun, very informative, a great way to learn things from great authorities in the various subject areas. So stay tuned for more of our content, and thank you for coming.
Thank you so much, Justin. Thank you to everyone at the Federalist Society. Thank you to Anya and Jason for joining us tonight for this spirited debate. We'll get straight to the questions, straight to the qualified immunity substance. First question, how can we balance the need for police to be able to do their jobs and protect their off-duty livelihoods with the need for accountability? And how does this relate to your stance on qualified immunity? Let's start with Anya.
Sure. Thank you very much for having me. This is really great fun, and I look forward to the discussion. Let's first define qualified immunity as the courts look at it today, right? So we kind of all on the same page and understand what we're talking about. So qualified immunity is a legal doctrine invented by the Supreme Court in 1982. The current manifestation of it is stemming from 1982 case called Harlow versus Fitzgerald. And qualified immunity shields any government official, right? Your mayor, your IRS agent, your Bureau of Land Management person, your police officer, your council member, your board member from liability if an individual whose constitutional rights were violated cannot show that there is a case identically similar to theirs in which the Federal Court of Appeals, controlling in their jurisdiction, specifically said that it is a violation of a constitutional right. So let me give you two examples to just kind of get a hang of it. Baxter versus Bracey was a case before the US Supreme Court last term. They declined to hear it. There you basically have a law enforcement officer releasing a dog on a suspect who already surrendered and was sitting up with the hands in the air, right? So Mr. Baxter, the suspect, surrendering suspect, eventually sued, basically saying, you violated my constitutional rights when you released the dog on me and I was surrendered. And to make his case, the officer said, qualified immunity applies, the lawsuit should be dismissed. And Mr. Baxter said, wait a minute, there is actually a case directly on point. That's why qualified immunity shouldn't apply, he says, right? In that case directly on point, there is an officer releasing a dog on a suspect who surrendered by laying on the side, right? And the court actually found that very significant. And the court said, no, qualified immunity does protect the government official in this case, because there is a difference between sitting up with your hands in the air and laying on your side, right? That's the kind of level of specificity we're talking about. Another case is McCoy versus Alamo, right? There, a prison guard pepper sprayed an inmate for no reason, right? And the Fifth Circuit was looking at this case. The prisoner sued, and the prisoner actually said, listen, there is a case directly on point. It says that it is a violation of constitutional rights to basically tase someone for no reason, right? To tase a prisoner for no reason. And again, the Fifth Circuit found that very significant, and it said there is a difference between pepper spraying someone for no reason and tasing someone for no reason. Therefore, qualified immunity applies and shields the officer, right? So the first thing to understand about the qualified immunity standard is that we're talking about very much of a specific level of, a very exact level of specificity, and it has to be in a very particular court. It can't just be in any court, right? And it's sort of this idea of somehow this test called clearly established law test is going to shield officers from liability. One huge thing to note is that qualified immunity shields anyone, right? Including those acting in bad faith, right? Another example, case called Jessup versus City of Fresno. There, if an officer executing a valid warrant went into a house and was searching for stuff and taking things for evidence, right? But in addition to taking things for evidence, the plaintiff, the person who sued, the individual, actually says the officer stole some money, a significant amount of money, right? So the individual sues and says, you stole my money. It's a violation of my constitutional rights, Fourth Amendment, unreasonable search and unreasonable seizure. And the Ninth Circuit in this case, and notice how I'm talking about all these different courts all across the United States, it's not just limited to particular area, basically said, you know what? There is no case specifically on points that says stealing is unconstitutional, right? Even though it's obvious, right? But it says, no, there is no case on point that says stealing is unconstitutional. Therefore, qualified immunity applies. We're not even gonna go into discovery. We're not gonna go look into evidence. We're just gonna shut it down right here and right now. So now to your question about this kind of balancing between jobs and job security, livelihoods, and accountability, right? Your question assumes that qualified immunity is the only thing standing in between the officer and the financial ruin. This is not true. First, frivolous lawsuits already get weeded out through other mechanisms. When, and I hope when, not if, you guys go to law school, you will learn about federal rules of civil procedure, right? And they have all kinds of protections in them, including rules on what you must say in your complaints in order for it to not be thrown out, or what you must show in order to be allowed to even be in court, so-called standing rules and such. Studies show that really only 4% of civil rights cases get thrown out on qualified immunity grounds. And these 4% are actually very important because they're very good, solid cases that cannot be thrown out through other means that weed out frivolous lawsuits or meritless lawsuits. So as a result, qualified immunity actually hurts those individuals with valid constitutional claims by denying them their day in court. So that's one reason why qualified immunity is not the only thing standing between the officer and financial ruin. Second, there is this Supreme Court precedent, right? A very important case called Graham versus Corner. And that case already provides protections for officers making mistakes and acting under time pressure. So I just want to quote from the case so you understand how much of a room this case provides. It says the reasonableness of a particular use of force must be judged from the perspective of a reasonable officer on the scene, rather than with a 20/20 vision of hindsight, right? So the court continues, it provides examples. It says, the Fourth Amendment is not violated by an arrest based on probable cause even though the wrong person is arrested, right? So it basically says you totally have room for error. Even if wrong person is arrested, you acted objectively, reasonably, Fourth Amendment is gonna protect you. You're not gonna be liable, nor by the then it continues, nor by the mistaken execution of a valid search warrant on the wrong premises. Again, reasonable mistake, acting in good faith, objective reasonableness standard will protect you under the Fourth Amendment. The court continues, the calculus of reasonableness must embody allowance for the fact that police officers are often forced to make split-second judgments in circumstances that are tense, uncertain, and rapidly evolving. I totally agree. And the court basically says, we understand that, and that's why we provide you with this reasonableness test that will protect officers who are behaving objectively reasonable. So a case like a case involving a mistake, right, would be dismissed. You won't need to get to even qualified immunity. A case like this, if somebody were to file it, would be dismissed on a failure to state a claim grounds. One of those rules of civil procedure that you can use to get rid of meritless or frivolous lawsuits. And finally, I just want to mention one important thing to keep in mind. Whose job is it to worry about incentives for officers versus protections of individuals, right? The courts here in the United States of America exist to protect individuals from infringement by the government. That's their number one role. They protect individuals, right? They don't worry, part of it, they think they do, and that's when judicial activism really becomes a problem. But generally speaking, they don't worry about policy considerations, right? They specifically focus on individuals and whether these individuals' rights were violated. And if they were, order remedy, right? That's the mandate, right? That's coming from the founding. For example, there is this famous case, the Apollon, right? And Justice Joseph Story, one of the most famous justices who ever lived, basically specifically says it is the job of the judiciary to look at whether the law was violated, right? And order a remedy if it was. And it is the job of the political branches like Congress then to worry about different policy considerations. So as far as courts are concerned, it is important to keep in mind that their number one job is to protect people from the infringement by the government, right? The Constitution limits what the government can do. And it's the job of the courts to basically say, stop, you can't do this. And this is frankly what really distinguishes this country from the kind of country that I'm coming from, right? I was born in the Soviet Union, right? And that was by far the biggest concern for its citizens, that if some government official would violate your right, what do? You have nobody to turn to. Nobody. You don't have courts to protect your rights.
Thank you so much, Anya. Jason, 10 minutes opening statement and responding to the question of balance with qualified immunity.
Well, thank you, Henry, and thank you to the Federalist Society of Georgetown. I appreciate the opportunity just to be here and to engage in this important conversation. I don't think it's so much a debate as it is a conversation from a couple different perspectives, and I can already tell I'm going to have my hands full tonight with Anya, who's obviously a very prepared and zealous advocate on the other side. So I would just like to kind of give sort of, as Anya began with an overview of what qualified immunity is, I just want to add to it a little bit from my perspective. And that is, governmental immunity is something that's part of the English common law that it was adopted by the United States at its founding. Governmental immunity, just basically meaning that government agencies, the federal government and the state government, are immune from lawsuit at common law. And that, has been refined over the years. There are various exceptions to that. And qualified immunity, as opposed to absolute immunity, which are both outgrowths of governmental immunity. The idea that, the king can't be sued. And of course, civil servants have become sort of the king, if you will, as they represent the government. The work they do is on behalf of the people. And the idea was that we, didn't want the people to be subject to lawsuit via their servants. So there are a couple distinctions I want to make between qualified immunity and absolute immunity. Some government officials do have absolute immunity from suit. Certain executives, elected, mayors and governors and the president, judges are immune from suit. They enjoy absolute immunity for judicial acts. Legislators likewise enjoy immunity for their legislative acts. Prosecutors are immune from suit. Absolutely, it's not qualified. It's an absolute immunity for anything that relates to their prosecutorial duties. So qualified immunity is kind of like a pretty significant step down in that it is qualified. It's only available in certain circumstances. And as Anya correctly pointed out, the current state of the law is that qualified immunity is available to government, I'll say servants, just means the people who get qualified immunity are not at the top of the food chain. They are lower ranking government officials, people who are not elected, people like police officers. Police officers really are sort of the quintessential example of the people who most often seek qualified immunity and most often, I would argue, need qualified immunity in appropriate circumstances. The standard is whether the law is clearly established. So just to be clear, in our Constitution, a lot has become established law over the years. Generally, it is a result of court rules. So the Supreme Court or one of the circuit courts of appeal create case law from the various amendments in the Bill of Rights. When we're talking about police officers and we're talking about seeking qualified immunity, we're almost always talking about the Fourth Amendment. The Fourth Amendment is what relates to, it's a prohibition on unreasonable searches and seizures, which has been extended to mean uses of force by police. So police uses of force, whether they're deadly force or non-deadly force or an unlawful arrest, are analyzed using the Fourth Amendment. So that's really where we focus. Most of the civil rights litigation involving police officers is around the Fourth Amendment, but not exclusively, just mostly. So that involves situations where police officers are making arrests, are conducting searches of people, searches of their homes, searches of their cars, and using force. The Fourth Amendment and the cases that sprang from it, including Graham versus Connor, which is a very important case that Anya cited, which does establish that in order for a police officer's use of force to be reasonable, or in order for it to be lawful under the Constitution, under the Fourth Amendment, it has to be objectively reasonable, just meaning basically that it is the same type of force that a reasonable police officer in that situation, looking at the totality of the circumstances, would make the same or similar force decision. It has to be reasonable. And there is leeway for officers to make reasonable errors. It is not terribly prescriptive, because we know that the situations that police officers walk into can be dangerous, stressful situations. They're rapidly evolving. Sometimes not all the facts are known to the officer, but yet they have to make a split-second decision. And so the courts have recognized that they do get a certain amount of leeway. However, that's not what we're talking about. That's Graham versus Connor. That is the law, and it's worked well since that case came out. I think it was in the 90s, early 90s. We're talking about qualified immunity. So qualified immunity creates an opportunity, if you want to look at it that way, to shield certain government officials. Includes all of these government agencies, not just law enforcement, but as I indicated, law enforcement is probably the highest risk activity that any local government is involved in. When I say risk, I mean that it's dangerous for the employees, but also that it creates risk for civil liability, both for the employees themselves and for the local government. And because of that, there is a certain balancing of trying to protect individual employees, not only just from liability, but also from the everything that happens when you get sued. So when you get sued, it does all sorts of things. It affects your credit report. It involves providing information and discovery. You have to respond to questions. You have to attend depositions. You have to retain an attorney. There's a lot that goes along with it before you even talk about actually having to pay money damages. So that really is the reason why qualified immunity exists, because we know that government employees are enforced, or are, as part of their job, they actually enforce the law. We know that there's a certain inherent risk of civil liability that comes with that, because to enforce the law, you also in some situations are going to have to do things like use force. Sometimes using force injures people and creates the opportunity for there to be liability. We also know that even though we have a great United States Constitution, and again, the Fourth Amendment is really key in a lot of what police officers do. The Fourth Amendment itself doesn't answer really almost any question about what is or is not lawful for the government to do. It doesn't prescribe exactly the extent of people's rights under the Fourth Amendment to be free from unreasonable search and seizure. So we have this enormous body of case law that's developed over the centuries that helps to police officers to understand what they can and cannot do. But that case law, as Anya even indicated, it's different around the country. There are different judicial circuits, and there are slight variations to how the Fourth Amendment has been interpreted across these judicial circuits. Likewise, the Supreme Court sometimes will weigh in on a particular Fourth Amendment issue, and sometimes they will demur and not take it under consideration. Sometimes they even change their mind. Gant versus Arizona is an important, fairly recent Fourth Amendment case that I think makes the point very well why qualified immunity is important, and that is this. Up until Gant versus Arizona, which I think was decided in the early 2000s, I don't recall the exact year, but police officers had the law was very clearly established that if a police officer made an arrest of a person from a vehicle, so they pull a car over and there's some reason to arrest a person, maybe they have an open warrant, maybe they have a suspended driver's license, maybe they have drugs in the car, they make the arrest, they remove the person from the car, they typically put handcuffs on the person. Then, as an exception to the Fourth Amendment, not an exception to the Fourth Amendment, but as a reasonable search that is permissible under the Fourth Amendment case law, police officers were able to conduct a full search of the entire passenger compartment of the car, looking for contraband, looking for anything that would enable the person to escape and other things, or allow someone to destroy the evidence. Police officers could conduct a search of that entire area. Well, that changed under Gant versus Arizona. So a couple of cops did just that. They made an arrest of a person out of a car. They conducted a search of the interior passenger compartment. I think they found a gun in that case. But as it made its way through the appellate process, it made it all the way to the Supreme Court, which is extremely difficult to do, made it to the Supreme Court, and the Supreme Court reversed itself under Gant versus Arizona and said, no, you can't do that anymore. It has to be more closely tailored search. It can't be a full search of the entire passenger compartment of the car. So they changed the law. The law was clearly established in one direction. They changed it and completely changed what the law was. So we're asking law enforcement officers to go out there and engage in all these discretionary acts. That's what police work is. It's so much discretion. Who should be stopped? Whether someone should be arrested? What should they be charged with? How extensive should the search be? Is there a warrant required? What type of speech is permissible? I mean, just literally, and these are police officers that by and large are making these decisions without the benefit of consulting with counsel, without the benefit of conducting legal research, without the benefit of, like in the case of a federal judge, of having a staff of clerks to do research and to write briefs and so forth. These are decisions that are being made on the scene in rapidly evolving situations that have to be made immediately. And so we want to give officers the ability to not really err, but just make decisions when the law is not clearly established. And that's what qualified immunity does. And I'll point out just in closing of my opening remarks here that, and Anya pointed this out herself, is that if qualified immunity was intended to, or was working as a shield to prevent police officers from being accountable in civil actions, constitutional civil actions, it's doing a horrible job at that. Because in this very recent study conducted by UCLA law professor, who looked at almost 1,200 civil rights cases involving law enforcement officers, a very, very small percentage, just under 3%, were actually cases that were kicked out of court, either on motions to dismiss or motions for summary judgment, based on qualified immunity. There were cases that didn't proceed through the process for other reasons, but just on qualified immunity was under 3%. So I think we're really, we're talking about a very small percentage of cases where plaintiffs aren't allowed access. They aren't allowed access to the courts based on qualified immunity. Very, very small percentage of the time. So I really don't think it's something that presents a big barrier. As to the really call of the question on accountability, I don't think, I think if we're relying on federal courts to be an accountability mechanism for police officers, we're really missing the boat, because accountability starts much, much earlier Really it's incumbent upon the local governments themselves to set up systems where they're properly hiring, selecting and training strong candidates for law enforcement, that they're properly supervising them, that they're providing ongoing training so they're keeping them up to date on the state of established law, because that changes all the time. It's very important that officers are kept up to date on that, are required to know what the laws are and otherwise be competent at their jobs. It's only when that completely fails that we rely on federal courts and even state courts to serve as a backstop to that, and for there to be accountability. But there's so many other checks in the way that really the governments themselves and the law enforcement organizations themselves are really charged with promoting that. Now, going forward, and I'll just be brief, and then we'll move on to the next question. But I think in the future, the solution is not creating greater opportunities or greater access to federal courts. It's really creating more transparency around what when we're just talking about law enforcement, more transparency around what law enforcement does. Quick example is body-worn cameras that are now ubiquitous. I mean, law enforcement, pretty much every agency has adopted them. To have better access for the media, for the community, to actually be able to see what law enforcement officers do, to be able to review themselves via the video, controversial or dangerous situations that officers have been involved in. So, and transparency certainly goes well beyond that, but I just think that that corresponds more with accountability than federal court access does.
So, Anya.
Can I respond?
Yes, I'll give you an opportunity to respond, but I also want to, as we transition into this deeper conversation about law enforcement, I want to also ask, from the police standpoint, if qualified immunity is revoked, what is the direct effect? And from an employment standpoint, are fewer people going to pursue jobs in law enforcement, as we also hear ongoing conversations about calling to defund the police?
Okay, so I would like to respond, and that kind of is going to get to your question very much. So Jason talked about qualified immunity doing horrible job in terms of weeding out cases, right? And he cited Joanna Schwartz's study, a professor from UCLA. And this is exactly one of the main reasons why there really isn't, qualified immunity is not something that's, qualified immunity is not the only thing that's standing between an officer and essentially financial ruin, right? This study is a great example. So Joanna Schwartz analyzed over 1,000 of civil rights cases, right? Where they're actually filing these lawsuits against government officials, including police officers. And these cases are being weeded out by other mechanisms that are in the federal rules of civil procedure, right? Like failure to state a claim, for example, because you can't meet the standard of Graham versus Connor as a plaintiff, right? So these cases are being weeded out under so many other doctrines. And only when these other doctrines, these pleading standards, all that stuff that protects defendants from being sued for wrong reasons, only when those doctrines don't work, that's when they resort to qualified immunity, right? So it's really showing you that qualified immunity is not doing work in terms of officer and financial ruin. There's so many other ways that we can protect officers if indeed they are acting reasonably. That's a very important study, and I highly recommend you guys get familiar with it and also read our op-ed. I believe my friend Patrick Giacomo, who is my colleague at the Institute for Justice, is joining us tonight, and he and I co-wrote the op-ed with Joanna Schwartz, explaining exactly that, why it is that qualified immunity really is not something that is going to deter officers from, trying to make these important decisions, which, by the way, they do. And I love our police officers. I think most of them by far are trying to do their best and doing important job, and it's important to have them, right? But qualified immunity is redundant for their purposes, and it's really harmful when it comes to individuals who want to vindicate their constitutional rights. And another thing that I do want to mention is it's important to talk about history, right? And Jason talked about it a little bit, but the qualified immunity is really ahistorical, right? Sovereign immunity, there is precedent, no question about that, right? King can do no wrong, indeed, right? That comes from Great Britain, though you can make an argument that we actually separated from that country because we didn't like that rule. But leave that aside. There is this sovereign immunity thing, right? But qualified immunity is new, right? It's really starting to creep up in 60s. And then the court announces this big standard in the 80s, right? Before then, there really isn't an example of qualified immunity type of, unless it's used in very particular specific situations, but not as this really broad defense. And important thing too to mention is that qualified immunity, again, applies to all government officers, and those mayors and the president, all those guys, they're still protected by qualified immunity. They also, some of them like prosecutors and judges, will be protected by prosecutorial immunity and judicial immunity, but they always have this bottom of qualified immunity. And it doesn't matter whether you're a law enforcement officer or you're a government bureaucrat, right? You're an IRS agent sitting at your desk trying to do something, right? It doesn't matter. Qualified immunity protects them all. And even though, you know, I would actually, prosecutorial immunity type of stuff, absolute immunity is indeed absolute, right? You basically can't put cracks on the wall with absolute immunity if the court basically says absolute immunity applies. But qualified immunity, there are also essentially no cracks on the wall anymore. It's very hard to penetrate the qualified immunity analysis once the government official actually invokes qualified immunity when he's being sued. But to kind of go back and address, again, reiterate the question that you're talking about, incentives for folks to go into police and work as police officers, I think they absolutely should. I think that's very important. But I also think, and there's a ton of data to support that, qualified immunity is not the thing that's going to protect them. There are so many other mechanisms that they can and do take advantage of. And qualified immunity is simply, you know, is really not there for that reason.
Jason, what is your response?
I would say that I agree that qualified immunity is not. It is not the end all be all. I don't think that alone makes the difference between being able to recruit police officers and not being able. You know, I'm sure if you gave police applicants a survey about what qualified immunity is and whether they want to proceed in the hiring process, if there's no qualified immunity, it's not going to make any difference to them at all. And in fact, not that many currently serving police officers would be negatively impacted by it, because as we understand, there relatively few cases are actually even dismissed based on qualified immunity alone, that there's many other reasons why, as Anya has pointed out, where cases may fail, may be weeded out, as she said, and that's true. And qualified immunity is only one of those reasons, and it's a relatively, in terms of numbers, it's one of the smaller reasons why a case may not progress. So no, I don't think there's any, it's not going to bring an end to law enforcement alone. But I also think that there are certain factors that, for proponents of changing qualified immunity or getting rid of qualified immunity altogether, they often cite sometimes it's a creature of state law, sometimes local law, sometimes just local policy or custom, where police officers who are sued and have to pay money damages, where the local government actually pays money damages on their behalf. And that generally is the case. That generally does happen for any government employee if they're successfully sued and have to pay damages, with some fairly small exceptions. Those damages are paid by the local government. So that's one of the arguments that you'll hear from Anya and her colleagues, is that, you know, it really doesn't make any difference to the officer anyway, because they're not the one that has to pay the damages. And that's really, you know, I kind of see that as two things. First off, it's a little bit beside the point, because, you know, it's like having car insurance. You know, if you have car insurance and, you know, you did something that you didn't think was wrong, and as a result you were successfully sued, it really doesn't matter whether your insurance company is paying your damages or not. It really, I mean, it's just a question of whether the damages, whether the case should have proceeded to begin with. But the other thing is that those laws and those policies and customs, those aren't etched in stone. I mean, those aren't constitutional. I mean, the next step is if you're able to eliminate qualified immunity, the next step is maybe go after these statutes or policies or customs that require local governments or local law enforcement agencies to cover damage orders on behalf of their officers and employees. That could be the next thing, and that would be extraordinarily damaging, because there would be, all it would take was a couple of cases in a jurisdiction where a police officer had to file for bankruptcy or lost their home because of a civil judgment. That would create a major problem. So I do think that that's something to be aware of. It doesn't matter if officers are shielded to some degree from that. Now, the next step could just be going after that, saying, well, police officers aren't sufficiently motivated to not get sued. They don't really care because they don't have to pay the damages. If that's going to be the next step, and it certainly could be, that would create a very significant problem. I do want to throw one more case out there too, and I don't want to get bogged down too much on Supreme Court cases, but I think it's just to kind of illustrate what I think is important to understand. It's very difficult to kind of understand the context of all of this if we don't tell stories a little bit about what things that have happened. Case called Armstrong versus Village of Pinehurst. I think it's a case from 2012, 2013, around that time, from the U.S. Supreme Court. It involves using it's from the Fourth Circuit Court of Appeals, which again, not the Supreme Court. It's sort of the next rung down, and only covers a certain geography. So the Fourth Circuit Court of Appeals found made law that only applies to the Fourth Circuit that relates to using taser. So when tasers are not terribly old technology, it's relatively new technology. Probably in the last, I would say, 20 years or so, they've become widespread in law enforcement. So when that technology first became used in law enforcement, there is no case law at all on tasers. There's no body of law out there for any agency to follow, for any individual police officer to consult to find out what is and is not going to be considered lawful down the road. So attorneys for law enforcement agencies help to develop policies that they think reflect good practice, that they think would be reasonable uses of force under the Fourth Amendment, and they do that. Well, that's what happened to these officers in this case, and it was in North Carolina, where these officers responded to a situation where the person had mental illness, had eloped or escaped from a hospital where he was being evaluated, and they were trying to get him into custody to get him back to the hospital. He grabs a hold of a pole or a sign, won't let go. They're giving him repeated commands to let go. He's not letting go. They're concerned he's going to get up and run or assault them. So they use a taser, so a less lethal weapon. They were trained to use it in those circumstances. They did use it. And they used it a couple of times, I think. Ultimately, they get this gentleman into custody. Well, later on, he dies. And I don't know if it was related to taser use or not, but the bottom line is those officers, after the case progressed through the system up to the Fourth Circuit Court of Appeals, were found to have acted unreasonably, that the way they used the taser was not reasonable and therefore was not constitutional. However, because the law was not clearly established at the time that they used the force, the Fourth Circuit determined that they were entitled to qualified immunity in that case, which is exactly why qualified immunity is essential, I would argue, because we don't know, if we don't know when the law is going to change, when new technology is being used, and law enforcement is changed very rapidly over the last 10 or 20 years, and will continue to do so in the future, employing different kinds of technology, especially in terms of less lethal force. It's impossible for officers to predict what a court may say down the road. The law is not clearly established in those areas. So to require those officers to face suits and liability and potentially have to pay damages, extremely unfair to put them in that position when the law is not clearly established. So I think that case really makes the point that, we have officers out here doing a job the way they were trained and in a way that seems reasonable, but a court may later find that wasn't reasonable, wasn't lawful. But as in this case, because there is qualified immunity, shield them from actual liability, because there was no way that they could have known or should have known to do anything different.
Okay, so I want to tie this next question into recent events. Regarding the death of George Floyd, it's been argued that the combination of methamphetamine and fentanyl in his body, mixed with pre-existing health conditions, exacerbated the injuries he sustained from the officer. Assuming police officers follow existing protocol, Should officers face blame for a death with complicated circumstances when they are unaware of these circumstances? And Anya, I'll start with you.
Sure, this is actually a great question, and it very much gets to the heart of the matter, right? So this is a great question, and qualified immunity prevents us from answering it, right? So George Floyd's family, hypothetically, theoretically, would file a suit, right? At some point, a Section 1983 civil rights lawsuit stating that George's rights were violated, right? Then the way it would work is, after they file their complaint saying constitutional rights violated, Derek Chauvin would invoke qualified immunity, right? Say qualified immunity applies. And so the burden goes back to the Floyd family, and the focus shifts from the constitutional complaint stuff that they are alleging to whether there is actually a case in the 8th Circuit, which is Minnesota, right? Federal Circuit Court covers that, 8th Circuit Court, whether there is a specific case in the 8th Circuit that says that it is unconstitutional for police to kneel on the neck of a handcuffed man for 8 minutes until he loses consciousness and dies, right? That's how the qualified immunity analysis is going to proceed. They're gonna tell George Floyd family, hey, show us a case where a circuit court, the higher court of appeals, specifically says that exactly what Derek Chauvin did was unconstitutional, right? Anybody would have known that what he's doing is wrong, but that doesn't matter, right? You're just looking at specific case on facts in this very jurisdiction. So this will be the focus. And all the stuff that you're talking about in your question, right? That only kicks in if the qualified immunity stuff is lifted and we actually get to go to trial. And then there would be the causation question, right? It would come up, and then these facts you're talking about would become relevant, right? Did the excessive force cause harm? Or did something else cause harm? But we can't even get to this question of something else causing harm to George Floyd because qualified immunity basically stops it in its tracks, right? And that kind of also gets to this bigger question of good officers, right? Who, because of qualified immunity and the way people perceive it, a lot of basically folks think that, you know, officers generally behave badly, which is so not true, right? By far, most of the officers are doing their darnest best and doing a very dangerous job out there trying to protect us. But instead, this cloud hangs over them, right? Like this case I talked to you about, the Jessup versus City of Fresno, right? There, the individual basically says, you stole money from me, right? You violate my constitutional right. This isn't my complaint. And the officer, instead of saying, listen, I didn't steal money from you. Here's evidence. I'm answering your complaint and I'm telling you you're wrong, right? Hypothetically, he could have done that. Instead, the officer actually says, qualified immunity, you are prevented from looking further into my case, period, right? And when you have this kind of analysis being conducted by the courts, then the only thing that's available for public record really is just the complaint that's actually stating that these particular rights were violated. And that's kind of creates a problem for some of the officers who are actually saying, you know, I am trying to do my best. And then they're thinking that people are going about and stealing money from people's homes, right? So that kind of gets to the heart of the matter, that qualified immunity actually prevents truth from coming out. It basically just stops any discovery, any fact finding in its tracks. And so that idea that you're talking about with George Floyd and that the combination of metamorphin and fentanyl in his body might have exacerbated the injuries, that stuff doesn't come into the consideration when you talk about the qualified immunity analysis.
Jason, would you like to respond?
Yeah, I agree with a lot of what Anya just said, especially with respect to the procedural aspect of it, that the first analysis, for if there's to be a claim of qualified immunity, is to resolve that before resolving, you know, the causation issues and other things like that. But I'm going to make a prediction, and that is that the city of Minneapolis is going to write a check with probably at least 6, maybe 7 zeros on it before any of this, maybe before a lawsuit is filed. qualified immunity is not going to be an issue. This is not something that's going to prevent the Floyd family from recovering an enormous amount of money from the city. And part of that is going to be law, and part of that is going to be politics. We're seeing that in other places. Certainly, we saw that in the Breonna Taylor case, where there was an enormous civil settlement, relatively early in the process before the criminal matter has been adjudicated. We saw that as well in a jurisdiction called Prince George's County, which is here right outside of Washington, D.C., where there was a $20 million settlement recently in a case where there is a murder charge pending against a police officer involved in a shooting. But and so this police officer's never even told his story. I mean, there are no surviving witnesses. We don't know what the officer's even going to say because he hasn't had his trial yet. And presumably, he's going to offer evidence in his defense at the trial, but yet there's already been a settlement. And I say all that to say that, qualified immunity is not a bar to recovery for any cases that we're hearing about. All of these families are going to be paid. Sometimes it's going to be because of the law, where qualified immunity is this is not going to be a shield to any of these officers. And sometimes there's some political element to it as well. With respect to George Floyd, again, I do think that there is liability. I don't think qualified immunity would protect Officer Chauvin. I do think that, another common argument in favor of reforming or eliminating qualified immunity is this idea that you have to have a case that is factually identical in order to have clearly established law. And I just, that's just not true. So if there's a case that relates to neck compression and the circumstances in which neck compression are appropriate, whether it's when neck compression is reasonable, whether it's a carotid neck restraint, or in this case, it's not a carotid neck restraint, it's kneeling on a person's neck for a long period of time. It doesn't have to be 8 minutes, doesn't have to be in identical weather or in the same city or for the same exact offense. There has to be sufficient guidance for a judge to determine that the law was clearly established. And I think that you'll find a body of Fourth Amendment case law that relates to neck compression that would be sufficient to overcome any claim for qualified immunity. And frankly, I don't think it's going to get that far. I think the city will simply write a check probably before a lawsuit's even filed.
Okay,
Yeah.
sorry, go ahead. A few minutes to respond.
Sure. One thing that's important to point out is that qualified immunity can be invoked at many different types, at many different stages of litigation, right? So you can basically, at the motion to dismiss stage, there are many different stages when defendants can get rid of a case. So at the motion to dismiss stage, qualified immunity can be invoked. Then it goes up on appeal. Then if the judge actually says, no, officer, you're wrong, or no, IRS agent, you're wrong, qualified immunity doesn't apply, it goes back. Then you go to the motion to summary judgment stage. And then this government official actually gets to go back to the appellate court and say, hey, I'm back, qualified immunity applies. And then they look at it, they might even again send it back. And then the officer or an IRS agent or any other government official gets to do it the third time too. So it's really qualified immunity. It's very important to know because it really increases the cost of litigation and creates other problems. Qualified immunity can be invoked by defendants at several different stages. They get many different bites of the apple in the process. Another thing that I want to point out is that it were true what Jason was saying about how closely the cases have to be related to each other. But unfortunately, what we're seeing, and more now, especially after Pearson versus Callahan, a 2009 decision in the US Supreme Court, is where really judges look very much at particular facts of a case, right? That's why I used that example in the Sixth Circuit, where an officer released a dog on a suspect who surrendered by sitting with his hands in the air, right? And they had a case that was very similar, where the court said it's unconstitutional to release a dog on a suspect who was laying down on his side. And the court actually said, laying down on your side versus sitting up with hands in the air, two very different things, right? Or pepper spraying versus tasing, two very different things. So it's clearly established test. The way it's being currently applied is very much based on very precise factual type of analysis. And with the family of George Floyd, I hope Jason is right. And, rightfully, there was a lot of publicity about what happened to George Floyd, but most of the individuals whose constitutional rights are violated don't get that kind of a spotlight, right? Don't that kind of spotlight doesn't shine on them. A lot of this stuff is happening, and there is really no public pressure. And when there is no public pressure, then it's a very different situation. So and qualified immunity presents a really huge problem for people whose constitutional rights are violated and whom nobody even people don't hear about those kind of cases very often, unfortunately.
Okay, I want to get to one final question from my side, but at this time, I'd like to invite any audience members to type their questions in the chat, and we can get to those right after the final question, probably around 9 o'clock. So my question is sort of pivoting away from the legal side. It seems like we're in agreement on the nuances and the challenges within law enforcement. But given the current climate of, at times, clear animosity toward law enforcement, how can we better spread awareness of these nuances and push back against the reactive nature of some of our, media-driven politics and discourse? I'll start with you, Anya, and then Jason, you can respond.
Sure. One way to do that is actually to get rid of qualified immunity, right? One of the biggest problems is what I talked about in terms of, all these articles in the newspapers talking about, for example, this cop, right, stealing while exercising a valid warrant, and then qualified immunity shielding him from liability. What often happens is, if you actually that cop who actually a good cop, and for some reason this lawsuit was filed against them, right? You want to answer the complaint. You want to say, you're wrong, I didn't do anything like this. What are you talking about? But instead, it gets stopped in its tracks, right? The litigation just stops. And the assumption is always whatever is pled in the complaint, that's what happened, because this is this individual's story, and the cop actually never, or any other government official, again, I just want to point out 1 million times that it is important to know that any government official can take advantage of qualified immunity. But so the assumption in public is, this is what happened based on the complaint, and the officer never files the answer. So one way to actually start really improving relationships is to get rid of qualified immunity and not have this kind of a doctrine prevent any kind of fact discovery and figuring out what actually happened. So that's kind of what I'm going to say, and I'm going to stop there. And it's uncharacteristically short for me, I know, but there it is.
Jason, go for it.
Well, first off, I do appreciate the question. I think it is an important question to consider in this time where it just seems like, from my perspective, that the police can basically do no right. That is what overwhelming public opinion is, and that opinion has been shaped, over the last several years, but in particular, since George Floyd. It was a seminal, maybe seminal is the wrong word, but it's an important shift. But I do think that people have been misled. I think they've been misled at the frequency with which police officers use force, which is really very rare. 99.9% of police encounters with people don't result in any use of force at all. And then those that do result in a use of force is typically a very minor force, like a handcuffing or some other very, very minor force. Deadly force is extraordinarily rare. And so I don't think people understand that. I think people have been led to believe that the cops are just out there, mowing people down and using force with absolutely no regulation or regard for human life. And it's just really not the case. So the question is, and your question, I think, is how, if that's true, I mean, you don't have to believe what I say, but it's what I say. If that's true, how do we get people to kind of understand that in the face of a lot of, misleading media narratives? A lot of it is social media, things spread on social media that are not true. And no matter, even though we all, I think, understand that, there's a certain susceptibility to believing things. The other thing I see is that people, no one that's listening to this debate, I'm sure, but some people are very susceptible to just accepting a very shortened narrative of what happened and not asking questions or requiring evidence at all. No critical thinking, I guess is what I'm saying, is that I feel that
critical thinking is starting to go by the wayside as we are distracted with, social media and our devices and this and that. It's created much less time for actually asking important questions and requiring proof of things. And these high profile police cases are an example of that, where, I get questions all the time from people that just make it very clear to me. We can debate, these cases are all very difficult. They're tragic in large part, but the facts are important. The actual facts of what happened are critically important to understand them. And there's just such the facts have sort of been cast aside, I'm afraid. So that's really my answer, is that we have got to transition to, more critical thinking. These are important issues to debate, to understand, to come to resolution on, whether we're talking about qualified immunity, which, by the way, I think is a very, very, my opinion, kind of a small player in this whole police reform landscape, but still one we need to talk about, and we are talking about. But I think the answer is that we've got to start getting some truth out there about individual cases of that high-profile cases that police are involved in. Also, truth about some of the context. As I said, 99.9% of police interactions involve no use of force at all, and the use of deadly force is not only extraordinarily rare, but based on the data that we do have, is plummeting and has been plummeting for decades. So I often hear people say things like, "Well, the police, it's just an epidemic of police killing people," and really that's just not true. But people do believe that. So what do you believe is true to you? And I think so it's incumbent upon law enforcement, on local governments, I think on media organizations, to try to be more responsible in how they report, and try to report on maybe a little more of a factual way, a little bit less of an emotional way. And I think that's kind of what, between social media, cable news networks, that's kind of what I think is driving us. Not that, look, I am not saying the cops are perfect. I'm not saying the cops don't make mistakes. I'm not saying there are cops that are just wrong and shouldn't be cops at all, should be fired. Some should be in jail. I agree with all that. But I think we have to focus our attention a little more critically on individual facts and context. And that's been lost. So how do we do that? My organization's involved in doing some of this, by doing some of these things, by engaging with the media as much as possible. And even we haven't done it so much in this COVID age, but we have a fairly sophisticated computer-based law enforcement use of force simulator. So basically, it's an immersive experience. We can put, reporters or public officials, or maybe we can put Anya through it someday, where you actually are equipped with, simulated tools that a law enforcement officer would have, and then you're placed in something that's sort of akin to a video game that you interact with. And you're a cop for a day. You have to make these decisions in these challenging circumstances. And it doesn't perfectly replicate the experience of what it's like to be a cop or walk in a cop's shoes, but it does a little bit. It gives you the feeling. It replicates the stress and the tunnel vision and some of the sensory distortion that cops experience, others experience when they're in these life and death situations. So it is helpful to get people to really start thinking about it a little bit from a different perspective than I think they're more accustomed to thinking about. So I think all of these things will just help, refocus us on ways that we can actually make things better, rather than just continuing to drive some of this rhetoric that is really destructive and harmful.
Okay, so I'm going to jump to our first audience question, and I'm going to paraphrase this to make it shorter, but it's directed to you, Jason, first. To the people that have had their constitutional rights violated but have their cases thrown out because of qualified immunity, how do we square the absence of a direct remedy with the role of the Constitution, the role of the courts, and Marbury v. Madison?
Well, I'm not sure I see the Marbury versus Madison connection, but certainly.
Yeah, there is a remedy.
Okay, all right, that's fair. I don't know that I can give an intelligent answer other than to say that, the right, there is a certain amount of notice that actors in the system have to have about the right. So if the law is not clearly established, a judge may later determine that the right existed, but should that subject any government worker, whether it's a social worker in the social services, a teacher in a school, or a police officer, should that subject them to individual liability when it wasn't clear that what they were doing was wrong? In fact, as I've tried to articulate, in some cases, they had been trained to do exactly what they did. And the training was not wrong. The training was correct based on the law as it stood at the time. So I think it's really there is a certain aspect of what judges and courts have to do that really balances public policy concerns. So if government employees can't with confidence approach their jobs and make discretionary decisions, which many government employees have to do, with some level of confidence that as long as the decision is reasonable, even if later on a court finds that it per se was a constitutional violation, that is not going to subject them to poverty. If you don't have that or some protection like that, then I think you sort of grind things to a halt with respect to government, and in particular law enforcement. Again, these are the folks that are most often making these decisions in the middle of the night with no opportunity to consult with anyone, no opportunity to do any research on what the right answer is, and oftentimes with the imperative to act like immediately. So you also, I appreciate and respect the fact that if, where there's a right, there's a remedy. I understand that as a principle and I agree with it. But there's always a but. And I think this may be one of those buts. And that is that if the people who are charged with providing protection to us have to pause or think twice or are simply frozen and can't act, then that creates a greater harm. And then maybe the best way to balance that is that we understand that we have a growing body of case law, constitutional case law. We will add new principles based on sometimes a court simply changing its mind, but in other times it may be related to technology. In policing, it might be less lethal technology. Because the technology has changed, so now the law must change. And just because we believed or forecasted the law would be a certain thing on a certain technology doesn't mean it'll always be that way. We shouldn't punish the implementers of that and the people who are charged without going out and doing the work. And that's the best defense I can offer.
Okay, Anya, a chance to respond, and then the next question will be going to you first.
Okay, great. So I don't want you guys to leave this event with the idea that somehow if an officer is, acting in a split-second situation, right, under stress, that somehow that officer is going to be found liable and is going to be kind of left on the hook for this. There are, again, protections, and Graham versus Conner is first among equals in basically saying 2020 is hindsight. We're not going to make officers, who act in stressful situations. I completely agree with that. We're not gonna have them go through all this terrible stuff just because they're actually putting their life on the line and acting in split-second decision-making. There are already protections for this type of scenario. Another thing that I would like to note is, you guys all know this dictum, right? Ignorance of the law is no excuse. That's how generally individuals are treated. So if there is an expectation from an individual to know the law and the ignorance of it is not an excuse, surely we should treat our government workers to the same standard. As to this Marbury versus Madison principle, I think the caller, the questioner, the attendee of this wonderful event really zeroed in on something, right? From the founding of this country, the idea is that when it comes to the courts, the focus is on the individuals and on their ability to be able to vindicate their constitutional rights or their individual rights, their common law rights, right? You go to court, you say, I was wronged by the government, and then the court analyzes it, looks at the facts, and if you indeed were wronged by the government, orders the government to pay you remedy. So that's a very important founding principle of this country. And it's a kind of principle that we need absolutely to carry forward. And qualified immunity, the clearly established test, the way it stands today, especially, has no place in the founding and in tradition of this country. And finally, Jason said something that really resonated with me. He said the facts are important, right? When he was talking about what we need to do to, kind of better relations and perceptions in kind of public sphere. The facts are indeed important. And the problem with qualified immunity is that once it's invoked, any kind of fact discovery is stopped. Qualified immunity says facts are not important. Let's not worry about it. Simply because of the status of a particular individual as a government worker, he or she gets to say that the facts are not important and the case should be dismissed.
Okay, so Anya, we have a question for you. If there is no qualified immunity, what would prevent or deter an individual from making false claims against police officers or any government official in hopes?
Absolutely, yeah. Yeah, that's a great question. And I go back to, again, the very first point I made today during this event, that, and I encourage you guys to go to law school. And when you do, you will learn the federal rules of civil procedure that provide a lot of different ways to dismiss frivolous lawsuits, meritless lawsuits, to basically tell individuals who are filing these kind of claims, the ones that you're talking about, to actually tell them you don't have a case and it is going to be thrown out, right? They are, and both Jason and I talked about this wonderful study done by Joanna Schwartz that essentially says that, most of the cases are gotten rid of not on qualified immunity, but on these other procedural protections that government officials have when indeed cases that are filed against them are frivolous cases or meritless cases. And they're things like, failure to state a claim, right? If there is an excessive force case under the Fourth Amendment and you basically can't really show that what the officer did is somehow, an unreasonable search or seizure, that kind of case is going to be dismissed on the failure to state a claim ground. It's not even going to get to the qualified immunity issue. So it's not qualified immunity that really prevents individuals from doing this. It's a lot of other rules of civil procedure, right? And people who wrote them, as well as the founders of the Constitution, right? They were very mindful of this kind of stuff. And there are already protections built into our system. Qualified immunity is very much of a novel development. Really, this clearly established test that exists today started in 1982, right? So before then, we really didn't have the problem with individuals, filing this kind of meritless lawsuits because there are other ways to get rid of them, right? And we're not gonna have this in the world after qualified immunity, just like in the world before 1982, we're not gonna have that problem either.
Jason?
Yeah, I mean, I agree. I really agree with that. I don't think that qualified immunity or the elimination of, I don't think it's going to impact false complaints at all. But let me just say this: that it is possible that some of the reason why the number is relatively low, the number of cases that are eliminated based on qualified immunity is relatively low, is that plaintiffs' attorneys are aware that qualified immunity is something they need to get past. And so sometimes they may allege in their complaint conduct that perhaps isn't what really happened, but it is, if they said what really happened, then it would basically be an issue that is not clear, where there's no clearly established law that was violated, and therefore the government actor would be likely to get out on qualified immunity, and rather they allege in a complaint conduct that is clearly established and would subject the government actor to liability. So they're able to skirt effectively around qualified immunity by representing facts in a way that perhaps can't be proven down the road, maybe not, but at least gets around qualified immunity, because that is an initial hurdle for a plaintiff's attorney to get beyond. So I think I'd stop short of calling them false complaints. I think just the lawyer's representation of the alleged facts in the initial complaint, may not be, there may not be evidence of the facts actually occurring that way, but at least it gets around qualified immunity, at least in the beginning. And I do want to just respond quickly to something Anya said in her response for the prior question, which was, ignorance of the law is no excuse, and that is true. But with qualified immunity, it's a little bit different. It's not ignorance of the law; it's a absence of clearly established law. So the idea is that the government actor doesn't have notice that what they are doing violates the law or the Constitution. So it's not so much ignorance of it; it's just not being on notice because it's not been clearly established yet. And so much of our constitutional law, the contours of our constitutional law is based, it's important to understand that you can't go to some repository that answers every question about what is and is not constitutional. Sometimes we have to wait for a court to decide. And in the meantime, we can't have government workers simply ignoring situations because the law has yet to be clearly established. We need them to act reasonably, and then if that is later declared to violate someone's constitutional rights, now we have notice that that particular thing violates the law. Tons of case law out there, so there's relatively few things now that fall in those cracks, but there are things, and there probably always will be, and that's why we need qualified immunity.
Okay, so we have one final question directed to Anya first, and then after this question, I guess in your response, you could just add a final closing statement before we wrap this up. So the question is, do you think the elimination of qualified immunity will have a quantifiable effect on police brutality, or would impact be mainly judicial rulings and transparency?
That's a great question. And in terms of what the elimination of qualified immunity is going to do, right, is to actually set up a system where constitutional violations are essentially going to be, the chance of a constitutional violation is going to be minimized on the front end, right? So what is likely, very, very likely to happen, and I'm assuming we all believe that, people and municipalities and government entities, they act in accordance with incentives, right? So what is likely to happen, given that principle of acting in accordance with incentives, is that the way the municipalities are going to be training their officers, right? Or the way, state agencies are going to be training their employees, that very much is going to, there's going to be much more accountability on the front end to make sure that the bad apples are actually not hired, or the bad apples are kind of weeded out and gotten rid of before the situation where the actual constitutional violation is going to happen. So what we really think qualified immunity elimination is going to do is kind of realign incentives where constitutional accountability is going to actually to come on the front end and will be at the center of kind of awareness when it comes to government entities who hire government officials. And I guess one additional thing I want to address, and you could maybe even consider it my closing statement, is this idea of notice, right? It's really, the way qualified immunity works has very little to do with making sure that officials get a proper notice, right? It's really not about that. The idea that somebody can a government official can go into someone's house and steal money, like, you don't need notice in case law that specifically says it is a constitutional violation to steal someone's property, right? Or there is a famous case, Harlow, at the Hope versus Peltzer, right, where a prisoner was shackled to a pole in the middle of a desert, and sitting there for hours, very thirsty, and this prison guard basically gave his dog water to drink, but the prisoner who was thirsty sitting right there shackled to a pole, couldn't do anything, just watch the dog drink that water, right? And Justice Stevens, to his credit, said, you know, you don't need notice to know that what you're doing is wrong, right? But you already have that notice just in like the obviousness doctrine in many of these cases. But so qualified immunity is not something that really that really is concerning itself very much with making sure that officers are on notice. If that were the case, there would be many other ways to ensure that that is actually happening. So with that, I think I'm just going to close my remarks.
Thank you, Anya. Jason, response and closing statement.
Yeah, I would just say I think it's more seldom than that the obvious the conduct by the government is so obviously unconstitutional or wrong even in these cases that oftentimes it's more subtle than that. And in some cases, such as a couple that I mentioned tonight, cases that I cited where the officers would have had absolutely no reason to believe that their conduct was unconstitutional because, in fact, they had been trained to do precisely as they had done, and the training was correct at the time that it was given. So there's really no reason at all to know that that a court would later determine that something that the officer believed they were doing right, had been trained to do it that way, would later be found to be unconstitutional and potentially without qualified immunity would subject them to significant liability. Respect to police brutality with or without qualified immunity, I don't think that there's going to be, you know, if qualified immunity were gone tomorrow, I don't think you're going to see, you know, police brutality change. But I think we have to distinguish police brutality with uses of force by police officers, which are not, you know, brutality when they are lawful and reasonable. I think what you would see if I could pick one impact, which I consider a pretty strongly negative impact, would be because police officers would no longer, they would feel much more exposed in terms of liability. Now, let me make clear too that police officers, that's not like the first thing in their mind is like, oh, well, I might get sued, or, you know, maybe what I'm doing is unconstitutional. There are many other things that prevent and that promote the idea of acting in a reasonable and lawful way and prevent officers from doing otherwise. Most specifically is the fact that they're subject to policies and regulations by their department. They have supervisors. They have body-worn cameras in many cases. What they're doing is they're increasingly is more of a rich record of what the officers are doing, and they are primarily concerned with, you know, maintaining their employment, staying out of trouble, doing a good job. Again, as I said earlier, you know, the prospect of being sued for damages is really just sort of a backstop when all of those things have sort of failed. But I also said earlier that so much of what police officers do is entirely discretionary. We expect police officers to actually observe and see suspicious circumstances and identify suspicious people or serious violations of the law that are happening right in front of them, identifying people who are maybe carrying firearms, identifying people who may be getting ready to commit a crime of violence, protecting people. That's really what we want the cops to do. And so much of doing that is sort of proactive work. It's not as if they're directed to a situation and are confronted with a decision to make. Oftentimes, they're just observing the environment around them. And if they're motivated and they feel somewhat protected, that they can act with a degree of safety, not only physical safety but legal safety, then they will act in a way to protect the community. Now, if they don't feel safe, if they feel very exposed, and I'm not talking about physical safety here, I'm talking about, you know, legal safety, career safety, that they may be less likely to act in a proactive way, to go out and seek in progress violations of the law, because all of those things are done based on their discretion. And if they feel that taking that sort of action, maybe it could be found to be unconstitutional or unreasonable or unlawful or inconsistent with their department's policy, it could subject them to losing their job, being sued for damages, potentially being criminally charged. I mean, all sorts of terrible things. And the more we push in that direction with our law enforcement officers, I think people do it in the name of accountability. But I kind of reject that in many cases, it really isn't about accountability. It's almost about retribution. Like we think all cops are terrible. Let's just go after all of them. And I certainly don't mistake Anya's position for that. But I think some voices do say that and believe that. And so I think we do have to be careful. Certainly we want great professional cops that do the right thing all the time, are accountable, effective. We want all those things, and we should keep working in that direction, because we're not quite there yet. But I fear that as we erode these relatively modest protections for police officers, we're really promoting inaction for police, and more of a model where police will respond to places that they are called to, and then sort of like the Maytag repairman or some firemen, they're just going to kind of sit around and wait for another call. And we know from just many studies that that's not effective law enforcement, that we need cops out there acting in a proactive and professional and lawful way to prevent crime. And I think Anya talked about incentives, and I think that's true. And we are creating a strong disincentive to that proactive work that we know promotes public safety. And that really is my concern. Question over police brutality really isn't the concern that I have. So I'll end it there for the response to the question. And just as a closing remark, I just want to reiterate what a privilege it is to be able to participate in this. And Anya has been a very, very worthy opponent, very strong and zealous advocate for her side. I hope there's not a vote on who won or who lost, because it may affect my ego permanently. But it was a great time, and I appreciate the invitation.
Thank you so much. I'm going to let Justin take the closing remarks. Before that, I just want to say this was a great debate to moderate. It's a great debate to watch. I think our viewers are reminded of what a good debate looks like. So, Justin, I'll let you take it.
All right, thank you, Henry, and thank you for moderating this debate. And a big thank you to Ms. Bidwell and Mr. Johnson for talking so eloquently and insightfully on such a timely and important issue. I especially want to thank you all for agreeing to be part of this discussion. So often in society at large, and especially on college campuses, there is not a big push for free discourse. So I really want to reiterate the importance of that. That's why we at the Georgetown Federalist Society and the Federalist Society in general really love to have these discussions. Everyone walks away having learned something. Maybe we changed a few minds. Even if we didn't, everyone learned something. That's really the point of all this. So I really want to thank Ms. Bidwell, Mr. Johnson, and Henry here for facilitating such an important part of college life and civic participation that is being so tragically overlooked these days. So a big thank you also to the viewers for watching. Please keep an eye out on our Facebook and Instagram pages for upcoming events. Usually every Wednesday at about 8 p.m. Usually 8 to 9:15 or 30 p.m. We have debates like this or discussions like this on various topics. So please keep your eyes peeled. We have some exciting ones to come, but I think this one so far takes the cake for the best one. Thank you all.
Thanks very much for having us.
Thank you.